everybody who's joining us. I'm Laura Skillen, the Executive Director of International Mediation Institute, and I'm delighted that we're here with you today with not only a fantastic guest, but with our friends from SIMI, the Singapore International Mediation Institute, who have helped arrange this event. So a little housekeeping first. Those who are joining and haven't used Zoom webinar before, you will see that there is a big Q&A button at the bottom of your screen. Please, if you have questions through the event, submit those questions via the Q&A section. First, there'll be a presentation, and then Anil will be going through and answering those questions. You will also see that there's the ability to raise your hand. If for some reason you cannot type a question in the Q&A, please do raise your hand. You'll find a little button there, and we'll get to that afterwards. But I'll now hand over to Marcus Lim from SIMI to introduce our guest.
Thanks, Laura. So welcome everyone to the collaboration between IMI and SIMI onto the Singapore Convention Seminar Series. We're very happy, as Laura said, to be running this. And with us today is actually a friend of mine, Mr. Anil Changaroth. Anil, very glad to have you with us today.
Thank you, Marcus.
Thanks for joining us. Yeah. So for those of you who aren't familiar with Anil, he's actually quite a character in Singapore. He's dabbled in quite a bit of work in various areas of dispute, I think specializing in anything from criminal to commercial and I think construction as well, right? But most recently, his foray into mediation has led him to explore online dispute resolution. And I thought, you know, it's a great way to start off this series by talking about online dispute resolution, because this is where we are now. Everyone's now online. We don't really have a choice. So it's a very relevant topic. It always is, but I think even more so now in light of the current situation. So Anil, very happy that you can join us today. And you know, before the webinar, we actually had a quick chat, and you were saying that you actually like to talk about how the online dispute resolution fits into the SCM, right?
Yes.
Yeah. So I know you've been practicing for a few years as a lawyer. And also as a mediator. That's for what, 10, 15 years now?
No, well, okay, it's been about 22, 23 years in practice.
22 years, okay.
Yes. And of which I've spent time both in-house with the international firm. Bulk of my work, 60% of my work is construction-related disputes, from mediation to adjudication to arbitration to dispute boards and everything else, and the remaining 40% I deal with all kinds of matters: crime, divorce, medical negligence, personal injury, all dispute resolution based. And yeah, interestingly, a lot more, far less litigation, a lot more with the other dispute resolution mechanisms.
Yeah. And just so the viewers know, Anil actually specifically requested I don't read out his CV because I'm pretty sure he'll be here all day. So that's a brief background on Anil, but that's not what you're here to listen. You actually want to hear from the man himself as to his thoughts about online dispute resolution, the SCM. So that's it from me. I'm going to turn the webinar hosting over to Anil, and also for Laura to facilitate and to run the rest of the show.
Thank you, Marcus. Those of you who've signed up for it would know that the topic is online dispute resolution in the Singapore Convention on Mediation. So a couple of introductory points first, if I may. Everybody knows this COVID-19 and the pandemic that's going on at the moment. Just last week on a LinkedIn site, I had put up a post through my publishers, Marshall Cavendish, and in which I said that the COVID-19 pandemic is dramatically disrupting how work and society functions. Social distancing is resulting in a greater use of technology for communication and interaction. And the Dispute Resolution Committee, mainly legal practitioners, the courts, dispute resolution institutes, are moving away from traditional form of resolving disputes, business disputes, and instead adopting an online dispute resolution mechanism and platform. And very soon, you're going to find that this is no longer just an option, but instead it's going to be a preferred choice for the majority, right? So that's just a quick take on ODR. I'll come back to that in a little bit more detail. But I think with that as a background, the next very important point I think that I must highlight is the Singapore Convention on Mediation. Those of you who are not familiar with that, on the 7th of August last year, 46 countries signed the UNCITRAL's Convention on International Settlement Agreement resulting from mediation. It's called the Singapore Convention. It's similar to what arbitrators know as the New York Convention, Recognition and Enforcement of Foreign Arbitral Awards, and the Hague Convention on Choice of Law Agreement of the 30th of June 2005, right? Now, what is very important about or critical about the Singapore Convention is that it's an international regime for enforcement of such agreements, international agreements. Essentially what happens is that if parties, international parties get into a dispute and they decide they want to settle their matter by way of a mediation, right? If that settlement has been recorded at a mediation in relation to commercial disputes that are international, that's when the convention takes into effect, right? Now, keep that in mind, that the fact that it is about international parties, it's about parties that are cross-border, across the world, having their matter resolved by way of mediation. Now, interestingly, our Chief Justice, the Honorable Chief Justice of Singapore, Sundaresh Menon, in an opening address at the Singapore Litigation Conference in 2013 said this. He said that access to justice need not entail having access to the courts if consensual outcomes can be reached in a way that secured acceptable outcomes which disputing parties can accept and move from. So the critical point what he said is that you don't really have to turn to the courts if parties can come to a consensual settlement of their disputes. And a critical part of consensual settlement is mediation, right? Now, you have to understand that dispute resolution can fundamentally fall within two broad areas: the consensual approach, which includes negotiations, conciliation, mediation, which is where parties themselves come to a settlement that they are comfortable with the aid of third parties, for example, right? That's consensual, right? You can either have a negotiator, a conciliator, or a mediator assisting you to come to a settlement. Or you have the other approach of dispute resolution, which is adjudicative. Examples of these are neutral evaluation, expert determination, dispute boards, adjudication, arbitration, and litigation, right? But there you have third parties that evaluate the matter, determine the matter, adjudicate the matter, and make awards or judgments in cases, and that's not consensual, right? Whereas in a consensual approach, if you take a look at mediation, right? Those of you who may not be familiar with mediation, it's really about parties sitting down and having their matter resolved to their satisfaction. They lead and initiate the options that they consider with the assistance of a mediator, and they come to a conclusion that they are comfortable with, right? And that's what mediation is about. And you can then see how the Singapore Convention expands that mediation to an international platform, allows for parties that are international to consider this approach of settling their matter by the mediation. And the minute the mediation is settled, it is recorded as a settlement, and the Singapore Convention allows it to be enforced across the world, right? Exactly like the New York Convention does with arbitration awards. So the fact that you have a mediated settlement that can be enforced around the world gives an added incentive for parties to consider that, listen, hang on a minute, I don't want to go into an adversarial approach to having my matters resolved. I want to see whether it can be within my powers and take it forward, get it settled. Now, if it's party going to be settling the matter, yes, there might be very little chance of there going to be a default or of any sort. But in the event there is some form of default, I have a recourse internationally to have it enforced. So that's the big framework of dispute resolution and the Singapore Convention. If you go down then to a little bit of the nitty-gritty of the convention, you find that the preamble, Article 1, Article 1A, 1B, Roman numerical 2, Article 2, all tells you about the framework of the settlement, the dispute that's going to be mediated and settled. And it all talks about the fact that it is about international parties coming together. Now, you then have a critical issue. When you're talking about international parties, they are across the world, all right? It's from country A to country B. How do they then come together to sit down and have their matter mediated? Are you asking them to set up a date and a time for them to all to fly into one particular place to have it mediated? Yes, you could do that. But in the current state of what's happening around the world, you find that everybody is in, many countries are in lockdown, many states are in lockdown, many communities are in lockdown, and you find a whole lot of people turning to other avenues of meeting and connecting, right? I was just describing before we came online, I was just saying that my office in particular, we've just now locked down from yesterday till we're going to be locked down till middle of next week. What happened is that a perpendicular street down from my office, which is 2 or 3 minutes walk away, has just been discovered there was a new cluster of the COVID-19 pandemic, and that it was a club, it's a pub, and it's been locked down, and it's just a street away from mine, and we felt that it was important that we too lock ourselves out and work from home. And what we did yesterday was that we tested what is called Microsoft Teams, and to see whether we can communicate with each other. And we ran our first meeting this morning, and we had documents that we could share and use. And it's interesting because, as I mentioned, my background is construction. And in construction, you find a whole lot of documentation that you got to go through. And one of the first meetings that I'm going to have online with my client this Friday involves 65 pages of what's called a SCOT schedule. A SCOT schedule is something where you set out each party's positions and the supporting documents that you have in support of that. Right now, we are going to go through an exercise without physically being present in my office, without the clients looking at the same screen in my office, but instead 6 or 7 locations, we're all going to come together online. So the question then is this: if you are talking back to the Singapore Convention and you're talking about international parties coming to try and resolve a dispute, what is the most efficient and practical way of doing it in this current environment? And therein lies the option of online dispute resolution, right? Now, many of you may not be familiar with online dispute resolution. It's the use of internet and web-based technology to communicate between the parties, right? And historically, it's been used for settling e-commerce, internet-related, Amazon-related disputes for several years now. But in the last couple of years, you've seen a whole lot of platforms coming online that's available, and parties adopting or using those platforms to try and see whether they can resolve their disputes, right? For example, in Singapore, I think late last year, the Singapore Mediation Center tested an online mediation platform, and I was one of the mediators on that platform. And what we had is we had a small dispute between an employer and employee, and they chose to use the online dispute resolution platform. And interestingly, it was through video conferencing, and we could have all the parties together. Initially, the parties were not very familiar with what exactly online dispute resolution meant to them, right? And they turned to me and just said, "So you will settle our problem, you'll settle our dispute." I said, no, hang on a minute. We are here, I'm sitting as a mediator. It's as though I'm in your presence, in front of you, and you can see both parties on the screen. We can look at all the documentation, and we are just going to go through, and I'm going to guide both of you to come to a settlement. Eventually, in that particular matter, we had to take it offline, right? Part of the reason why was because one party really didn't understand the essence of mediation as opposed to the online or the ODR platform. They didn't understand the fundamentals of mediation itself. And so I had to end up sitting with them face to face to discuss that. But I think with international parties on an international platform, I don't think you're going to have a problem of the parties not understanding what mediation is about, because when they get into a relationship and they decide that they want to have their matter mediated and settled, they would have some background, some knowledge and experience about what mediation is. So getting across that hurdle of making them appreciate or understand mediation is not going to be an issue. It is getting them to work on an online platform that may be a little bit more tricky. But it's so interesting. Yesterday, like I mentioned, when in my office, we tested out Microsoft Team. It was incredible. My trainee could just pull up a document, put it on the platform, and I could see him making the corrections and adjustments to it. It wasn't a case of him emailing me that template and then for me to look at the template while he's amending it on one side. We were working on it together on the same platform, and it was so easy, right? So the point about that is that you find that there are ODR platforms that are going to be coming online. There are ODR platforms, I'm going to go through a couple of quick examples of it, that actually makes it very easy for you to be able to be on it. And in fact, you'd feel that you're exactly in the same room. You feel that you're in the same room working with the mediator, looking across the table from your opponent and trying to settle the matter. It feels almost no different from that, okay? So you have to appreciate that there are the avenues, there are platforms, all of these things are coming online. There are also a framework being set up for how ODR works. And then the biggest of that is this, it's called the Asia Pacific Economic Cooperation, APEC. They have what is called an online dispute resolution collaborative framework 2019, right? Late August last year, the APEC ODR framework and model procedural rules was adopted in Chile by the APEC nations. And they set a framework which describes and tells you how the ODR, resolving your disputes by ODR works and what the framework should be, setting some guiding principles that parties should follow. It tells you about how the technology works, and basically it sets a clear framework for taking your disputes online and getting it resolved online. So that's a very interesting initiative by APEC. If you have an opportunity, I'd suggest you go take a look at that. It's a culmination of a collaborative framework and a working group that was concentrating on micro, small, and medium enterprises, and eventually that led to setting up this framework. So what you see is that it's no longer just about eBay or Amazon and resolving small claim disputes. You now see that in the whole region of APEC, there's a framework being set up for you. And if you take a look at that framework and you then take a look at the platforms that are available internationally, you realize that ODR is no different from any of the other forms of dispute. And exactly like what I said in the start, eventually you're going to find that it's no longer just going to be an option. It's going to be a platform that everybody wants to turn to, because it's fast, it's efficient. You don't have to travel. You don't have to deal with accommodation. You don't have to deal with a whole lot of other issues. You just come online wherever you are. Doesn't matter what time of the day, and you can just communicate and look at some of the people that we have here now. We've got one from Jessica from SIMI that looks like she's from out in space because her background has been changed. Laura has got a kitchen, and I saw the first question that was raised by someone was that there was an interesting kitchen background, right? But that's the kind of framework that you have. Now let's take a look at, for example, whether or not there are platforms available at the moment, ODR platforms available internationally. The first one I want to highlight is China International Economic and Trade Arbitration Commission's online arbitration, CTEC. They have an online arbitration that sets out a rule and a framework and how B2B, business to business disputes can be settled through their online platform. You also have the Russian Arbitration Association's online arbitration. They too have an set of arbitration rules and how the arbitration can be dealt with in an online platform, right? So these are two of the big ODR platforms that are, or ODR dispute resolution mechanisms that are available. All right, now, if you keep that in the background and come back to the point about what I said about the current pandemic that's going on, right? The Singapore judiciary just last week announced that that ODR measures are being implemented to ensure that the continuity of the court operations and services while safeguarding the health and safety of the practitioners. So you find that the judiciaries in several countries, not just Singapore, also in China, are taking steps to move their pre-trial conferences, their case conferences, all onto an online platform. I've, since 3-4 weeks ago, I've had a telephone conversation on a matrimonial matter where the court was asking us for a case update on what's happening. My associate, my colleague, Shafiq has gone online to deal with industrial accident matters, and including a high court trial that we are trying to decide on witnesses and when the witnesses' statement should come out. All of these are being put in place. Back to the point about last week's announcement in the Supreme Court of Singapore, judiciary is implementing measures across the state, family court, the Supreme Court to allow more pre-trial applications, case management, matters that are going to be mediated, all by way of video conferencing, phone calls, directions and submissions are also being asked to be put online. Something that we've been doing for a while now, but it's just that the communication between the parties and the courts are also going online, all right? In the same announcement last week, our Honorable Chief Justice Sundaresh Menon also stated that the COVID-19 pandemic has caused unprecedented disruptions in the daily routines of institutes and individuals and demands a collective response which entails being willing to adopt, to change and pursue new solutions to the access of justice system in a new and perhaps unfamiliar way. So that's what we are going to. And what you're going to realize is that when this pandemic is over, I think a lot of people are going to be so comfortable in this new environment of going online, working off the office, not from the office, several people from different parts of the world coming together online, sharing documents, amending their documents, going through arguments, presenting their case, looking at submissions, looking at witness statements and cross-examining. All of these things are going to go, and I don't think we will go back to the old ways. I think we are moving to a stage where this will now become a norm, and it's going to be what parties want to practice, parties will find comfortable with and all that. Now, the last part I want to just highlight is that there are several initiatives that are taking place across the world that you find a lot more approach to dealing with matters online. So for example, the International Center of Dispute Resolution, the international arm of the American Arbitration Association, have got a platform where your case for arbitration can all be administered online, right? And they've got something called Clause Builder 2, which helps you monitor and manage your arbitration case online, all right? Out in Australia, there's the University of South Australia is investigating if virtual reality could offer a cost-effective option to jury viewing, all right? So that's another example. Another example that people are looking at is artificial intelligence. Whether or not, we're not at the stage, I'm pretty sure we're not at the stage where artificial intelligence would come in to decide on matters, but artificial intelligence can eventually help aid in the process of ODR. Something that I've been looking at and possibly might work on in the year coming up is virtual reality. Whether or not while as much as the example I gave you of the Singapore Mediation Center online mediation that I conducted, where I have the parties come online and I see them on screen and they see me. Can you imagine if that could be placed in a virtual reality to make them feel like they are in a room, that they are in a physical room, and that they are sitting across the table? That could be a next stage of taking this online dispute resolution. So something that I'm working on. But coming back to the focus of what I've just discussed, even in China, the Ministry of Justice and Supreme Court have earlier this year on the 3rd of March made announcements about how they are emphasizing the importance of ODR, and they were jump-starting the economy and having matters and disputes dealt with on an online platform. Now, if you take all of what I've just said into context and come back to the Singapore Convention on Mediation, you can appreciate how it is going to be so easy if you use online dispute resolution platforms and mechanisms and frameworks like the APEC framework that's set in place. If you set that as your ground rules, having matters mediated, international matters mediated online is not going to be an issue at all. In fact, it is going to be a value add to the Singapore Convention. It's going to be, you know, parties who are going to jump at the first opportunity they have and say, listen, this is the platform I want to use. This is the framework I want to use. I want my matter mediated using the Singapore Convention as its framework, and so that I have a decision that I can be comfortable with and I can turn to enforcing if at all I need to eventually, right? So it's not rocket science. The word online dispute resolution, ODR, has been circulating for a while. I had my first article in the Asian Journal of Mediation in 2016, setting out how it could work in the construction industry. We now, late last year, in December last year, my second article on ODR came out again in the same journal, expanding on it. And we now have the Singapore Convention that actually fits perfectly into this, whether ODR fits into the Singapore Convention or the Singapore Convention fits into ODR. It's almost seamless because you're talking about parties internationally wanting to resolve instead of having to travel, instead of having to arrange for a jurisdiction that they think they're comfortable with. You just go online, right? You can share all your documents when during the mediation process where some parties may feel that it's necessary for them to review the documents. They can do that as well. But you have to appreciate one thing, that if you go back to the fundamentals of mediation, there are a couple of things that become important. Mediation allows that face-to-face contact. Mediation allows that face-to-face interaction. Mediation is about the parties and what their interests are. It's not about the parties and their position. So the question that you may have is, can all of that be settled by going on an online platform? My answer to that is yes. My answer to that is, if you're not comfortable yet, get yourself into, if you are in a position where you're being locked down, you are really going to see that Zoom, the Microsoft Team, and all the other platforms that are available are going to make it so easy for you to interact between parties, so easy for you to communicate between parties, and mediators are also going to find that that personal touch of them sitting in front of the parties, looking at the parties in their face, trying to figure out what their concerns are. You're going to find that doing it online is eventually going to be the norm. It's no longer going to be so technology-based or distant or not personal. You're going to find that it is so easy to communicate, and all the fundamental things that you learn about mediation, all the techniques that you learn about sitting as a mediator, you're going to be able to apply that 100% even in an online platform. All right, so with that, maybe just one or two concluding points. I just want to say that the ODR mechanism is paving the way for quicker and speedier resolution of disputes. There's also this thing about online courts of the future, whether or not the courts can go online as opposed to being physically present in a place and in a certain jurisdiction. All of those things are things that are going to be kind of past. It's going to take us to the future where it is going to be so seamless for us to communicate, for us to deal with disputes, for us to go mediate disputes online. All right, and that's it for now. I think that's all I have to say about online dispute resolution in the Singapore Singapore Convention on Mediation. Shall we take some questions if we are there yet?
Yeah, I think so. So thank you very much for that very interesting presentation, Anil. I think you can see the questions in front of you. So if there are some that take your fancy.
Okay, so shall I, let me just pop that up. The first came in at 7:10. Doesn't requirements of any form of enforcement in mediation itself mean that the mediation has failed? Yes. Most of us appreciate the fact that mediation is about parties coming to a resolution themselves, and therefore the chance and the possibility of any one party defaulting is very minimal. I agree with that. And in fact, up till maybe about June last year, I too was of the view that, hang on a minute, if its parties are going to come to a mediated settlement, why would they have a problem and why would they need to consider enforcement? And then I started reading just before the convention was signed in Singapore. I started reading and I found out that the world over, they have different views about mediation. They have different views about what it can do. And there are countries where they say that there are no regime in place or no mechanisms in place for mediation to be a dispute resolution method in their countries. And therefore they feel very uncomfortable that mediation seems to them, to some countries and some jurisdictions, a means that has got no foundation, no base, no sound, concrete base as it is. So what actually the Singapore Convention does is that it allows these countries, jurisdictions to appreciate that actually, hang on a minute, if you feel that the regime and the framework is not clear, actually we have a regime that if there is a problem with the settlement, you can get it enforced. So it's not really a question of people having to adopt or go out there and get it enforced. It's the people appreciating that there is a mechanism in place if I have a problem. And that, to a certain extent, gives a lot of confidence to people and to appreciate that, yes, I want to go down the path of mediation. All right? So it's really not about needing to enforce it. It's about, in my opinion, personal opinion, it's about appreciating that there is that avenue there, that there is that framework there. If there is ever a problem, I can go down the path. Right? That's all. That's what I think it is. I hope I've answered that. The next one that came in is, I am a mediator and would like to know your thoughts on how the mediation process in ODR can move parties to an effective consensual outcome when the process is really human, with emotions, apathy, listening, forming a key part of the process. And I think the Singapore Convention is a plus for cross-border. Oh, sorry, that's a second part. So the first part, I think I've answered that to some extent. When I described to you that the Singapore Mediation Center had this mediation, they were testing the mediation, and I met with parties, and I realized that in that particular example, eventually I had to take it off the platform because the parties didn't appreciate what mediation was to its core. But in my interaction with the parties, to be honest, I could see their expressions. I could see where they were coming from. It almost felt no different from being in their presence. And if you are a mediator that has been practicing mediation for a while, you learn the art of appreciating the nuances of the people's disposition and mannerism, and you can pick up. And I'm telling you, with great platforms that are available, you find that it's no different at all from being present right smack in front of them, right? Of course, I also mentioned to you about virtual reality. It's something that it's in the pipeline, and it might help parties feel a little bit more confident that, okay, I feel like I'm in an environment where there is a table and a meeting and we are sitting across and all that. But that's part of way in the future. What I want to come back to is this thing about emotions and human and apathy and all that. You can do that. And you really have to try a platform. And once you try a platform, you would see that you can really communicate and relate to parties as much as you are physically being present. The second half of that question was that I think the Singapore Convention is a plus to cross-border mediation via ODR, which is environmentally friendly and cost efficient. I think the more important than that is that because the Singapore Convention is about international disputes and resolving international disputes, the ODR platform gives you an incredibly user-friendly and fast approach to taking the mediation to settlement without having to worry about the travel and everything else that comes with it. Environmentally friendly, I suppose so. But you know, when this pandemic is over, I suspect that there will be a whole influx of people who want to still travel because they want to get out and get around and feel that they are out in the open. So the part about environmental friendly, I don't know. Cost effective, yes, most definitely. Next question, Joseph Khan. What are your single biggest challenges that you face in adopting online mediation? How do you envisage to overcome it? I suspect for some time to come, it might be whether or not parties understand what mediation is about, first of all. And the example that I gave you was exactly the case where the parties really didn't appreciate what mediation was, and they just thought it was an online means of resolving a dispute. And to be frank, the one party who was making the claim kept coming online and repeatedly telling me, so you'll settle the matter for me, sir. So you will settle the matter for me, sir. And I think what happened was that he felt that because it's online, somebody else does everything for him and gives him a decision and says, pay him up, right? So I think the biggest hurdle is that the part about appreciating what mediation is about. If you appreciate what mediation is about, then I really don't see a hurdle or a big challenge going online. You really have to, I can't describe it, but I think you really have to be practicing it, trying it out, and you'll see that you can see the expressions, you can see the mannerism, you can see the disposition as well. In fact, the interesting thing about going online is that the parties are actually facing you. Whereas if in a mediation, the parties may be sitting across each other, looking at each other, right? And you may not catch on some of the nuances of the parties. Whereas if you do it online, you find that all the parties are looking at each other, right? So in fact, it's a lot more helpful in that sense that human touch is there quite a bit more, all right? So I hope that's answered that point. The next question that came is from Nairobi. Thank you very much for the time, expertise, and insight. The question is, what are your views in respect to the UN Singapore Convention in respect to mediation being able to serve disputes in an evolving digital-based supply chain, specifically the digital online marketplace? Many global producers, corporations, each with its own contract terms, channel to one overseas vendor or courier distributing to multiple buyers, shoppers, and intermediaries from multiple countries, each with their own local trade laws. Okay, let's take it back again. You must remember that the Singapore Convention is about mediated settlement, so, and international, and it's on commercial matters. So it doesn't matter the background to the commercial matter, whether it's digital based, whether the parties are all over the world, whether the parties come from jurisdiction and with different laws. The fundamental of it comes back to the fundamental of mediation. The fundamental of mediation is parties sitting down to come to a resolution that they are comfortable with. Those of you who practice mediation to some extent would know that going into the factual matrix of the matter is not what is going to get you a resolution. Going into the legalities of the matter, the jurisdictional issues of the matter is not what it's going to work. What is really going to work is what the interests of the parties are, what parties feel comfortable with, what are their grievances, and all of that. You don't have to worry about whether the parties are all over the world, whether there are different channels, whether there are different distributors. All those things don't come into play. What comes into play is whether or not, one, parties want to have the matter settled by mediation. Two, whether parties want to, are open about what their interests are at the end of the day, not their positions, what their interests are at the end of the day. And with that framework, it doesn't matter what the background of the matter is. Parties can reach a settlement. And again, on the point that I said, why you need enforcement, the idea of there being an enforcement really just gives party the comfort that when they settle this matter, if they do face a problem, they can get that taken care of. That's all it does. All right, I hope I've answered that question. Next one was this. What is the difference between ODR and the traditional mediation method? Is the only difference the utility of technology between them? Now, the traditional mediation methods are face-to-face, sitting down in front. ODR is the online dispute resolution method. That means you go online, you got the examples I gave you of the CTEC and the Russian rules that they are in place. That sets the framework, so the rules can be same as any other mediation that you're dealing with. The only real difference is that you do it on an online platform. You don't physically meet with the parties. You see the parties, you interact with the parties, but you're physically not at a 1 meter distance and proximity. Right? That's the only big difference, right? The second half is the only difference the utility of technology between them. Yes, to some extent. Parties must have a computer that they can use. Some parties may not have a computer of their own, but if they go to the dispute resolution center, the dispute resolution center would have a computer for them to use, and they should be as comfortable as them being in a room where the mediation is being conducted. So that's pretty much okay, I think. Right? So that's really what the difference is. Now the next question, in cross-border mediation, how much do you as a mediator go into the legal issues of conclusion of the mediation agreement, whether it can be in electronic form and in what form is necessary for enforceability of the relevant countries? Okay, so starting point is this. Legal issues, insofar as the dispute are concerned, you know, the mediators amongst us would know that that is not a critical issue in mediation. We don't look at the legal issues of the disputes in place. But if you're looking at the mediated agreement, yes, the mediated agreement must conform to the requirements under the, say, for example, the Singapore Convention. If you read the articles of the Singapore Convention, it spells out in detail what kind of a matter it relates to. So as long as the mediated agreement sets out that framework and details the provisions that are in the convention, it should be enforceable. You know, remember right from the start, I mentioned to you Article 1. You take a look at Article 1, Article 2, and it tells you what the framework is for the kind of mediation that can go. So for example, if I just read off, Article 1 makes the Singapore Convention applicable to agreements resulting from mediation and concluded in commercial disputes internationally between parties with at least 2 parties that have a place of business in different states. So as long as the mediated settlement, you describe that this is between a party A that is residing where and between a party B that's residing where, you would cover the first hurdle or in Article 1 that talks about different states, or in situations where both parties have their place of business in a singular state, where the said place of business is different states. So you describe that in the agreement, then you know that you're conforming to the requirements under the Singapore Convention, and so enforcement is not going to be an issue after that. The next one, Salma says, I would ask my question. I'm from Tunisia, I'm an assistant professor, and since 10 years we are, as jurists, talking about ADR, less about mediation, but we aren't seeing that these methods are followed in practice. It is not because of a lack of awareness, but because of the absence of investments in these methods, and that they are confined as specific tools for a closed network of lawyers. My question is about mediation is, how is it possible to expand this process when there is a big part of lawyers that are not convinced with the importance, and they are not open to promote this practice, even if it is familiar to our tradition and civilization? Okay, let me explain. Let me quickly give you the example I use very often when I'm communicating, when I'm speaking on ADR and mediation, and a large portion of the people that have reservations are lawyers. So I always use this example. I had this dispute where the claim was about $3 million US, and my client was the defendant in the matter. They came to me and said, I have this, I have no money, I want it to be mediated and settled. What can we do? I explained to the client that at the moment the claim against them is $3 million US, and they have no defense and no counterclaim. Unless and until they file their defense and counterclaim, you will not see the claimant coming to the table to have the matter mediated. Now, we filed the defense and counterclaim, brought the difference down to about $1 million. And while we were attending court, I just mentioned to the lawyer in passing, he said, shall we mediate? The next thing we know, we were in mediation. By 3 p.m., the difference had come down to about 300,000 that the claimant was willing to accept. And my client said, no, I'm not paying a cent, let's walk out. I said, hang on a minute. Please, can you consider making an offer to settle this matter? And the client looked at me and said, how about your fees? I said, my fee is very simple. 8 months down the road, I'm going to bill you X dollars to get this matter to trial. At the start of the trial, at the end of the trial, you're never going to be a happy person. I'm always going to be a happy person because I billed you X dollars, right? I'm saying, please keep that aside. Consider whether or not you want to make an offer. He made an offer. We got it settled. We got it wrapped up that evening at a very small sum, mind you. And my client looked at me again and said, you've lost the chance of going to trial and a whole lot of fees. I said, that's not very important to me. What's important is that you convey that we've taken this approach to resolving your dispute to your friends. And your friends, one of them is going to come to me in maybe 2 or 3 months. And those 4 parties may go on to tell other 4 parties, and so on and so forth. And you find that eventually people are all going to turn to this approach. I have the opportunity of potentially 12 to 15 new clients in the future, but that's the future. So it's about how you communicate this method of dispute resolution to the fraternity, and it's really about ADR. ADR is no longer about alternate dispute resolution. It's really about appropriate dispute resolution. What is appropriate? All right. So I think you've got a long path down. It's going to take a long time for you to get to the convincing everybody else that there are dispute resolution mechanisms, but it's a whole exercise that's going to take some time. Okay. Next question. Are you aware of any ODR providers that relied on the UNCITRAL technical notes on ODR 2016 in developing their procedural rules? Okay. A little bit of background. I think the UNCITRAL technical notes on ODR 2016, it hasn't, correct me if I'm mistaken, it hasn't gone forward. It stopped short of that technical notes. They haven't set a framework. They haven't set a clear guidelines. And that's why I mentioned to you APAC and what APAC has done. So they have set a framework and guideline. And the APAC, when we met in Osaka last May, for the working group that developed the framework, there were ODR providers present. And I think the next stage of APAC, what they will do is that they will work with the ODR providers to see whether or not their platforms can be adjusted to accommodate the framework that's set in place. So it's in the pipelines, I think, not particularly the Ancestral 2016 point that you raised, but the future is going to be there. But to tell you the truth, when we interacted with these ODR providers, which one of which is called Resolve Disputes Online, right, RDO, their framework and their platform is already accommodates whatever is necessary insofar as having a matter settled by mediation is concerned. It's not a difficult exercise, right? But they probably now have to get it streamlined to the APEC framework, but it's something that should be workable very soon. Next question: if there is a difference in the meaning of mediation as you suggest per country, then if you have a party in India, another in Singapore, and the mediation is in Dubai, then doesn't that raise jurisdictional issues? Which country's perspective holds heavier then, even if the rules of mediations are clear? Okay, tricky, but let me just start with this. If you understand the fundamentals of mediation, you know that mediation is about parties coming to a settlement on their own, right? Now, when parties come to a settlement on their own, they can then sign an agreement. Now, that agreement between the parties should be enforceable regardless of the jurisdiction that they come from, except if they, of course, if you enter into an agreement to deal with a criminal matter or criminal conduct, that of course may not be enforceable. What I'm saying is that a mediated settlement is like an agreement. It's basically an agreement between the parties. And if it's an agreement between the parties, and it's consensual between the parties, and both parties have said that they want to get into it, I don't think you'd have a problem whether the party is from Singapore, whether the party is from India, whether the mediator is from Dubai or not. The mediation process is something that the mediator would have to set in place and the parties would have to agree to. And once that is done, then getting into the mediated settlement that complies with the Singapore Convention shouldn't be a problem. So say, for example, in the mediations that I conduct, the ad hoc mediations that I conduct, the parties come to me, I set out a framework for them and say, okay, this is the framework of the mediation. Our parties are agreeable with this. And the parties sign off on a mediation agreement, meaning agreement to mediate, right? And they sign off on that. They are okay with the framework. They are agreeable with how it should be conducted. And so the issues of country, jurisdiction, and all that don't come into play at all, right? Your last part of your question, which country's perspective holds heavy then? I don't think in a mediation it comes into play at all right? Moving down, meaning, oh, they're talking about seat of mediation. Oh my, sorry, I've lost that question. Seat of mediation, no, hang on. Don't go there. None of those things matter because we are talking about, you're not talking about arbitration where a third party, independent third party makes the decision. You're talking about mediation where parties themselves agree. And you know, where they sit and agree doesn't matter at all. It cannot matter because it is parties consensually agreeing to an end result of their dispute, right? So I don't think seat of the mediation, jurisdiction, all those things come into play when you're talking about mediation, which is why I think in the start, I spoke very briefly about what mediation is about as well, because you have to understand the fundamentals of consensual as opposed to adjudicative dispute resolution. Next question, the future use of AI is very interesting. Do you think it will be possible for AI software to help mediators in managing parties' emotions and enhance empathy? I hope not. I do not hope that happens because, you know, at the end of the day, no matter how much artificial intelligence is in play, right? The artificial intelligence can work with statistics, figures, computation, and so on and so forth. But the essence of the human touch of mediation cannot be replicated on an AI. I don't think we are 10 years closer to that. We are nowhere. I think we're maybe 50, 60 years away from ever getting to that kind of a state, right? So if you're talking about AI, it's really about assisting the mediator, but not in dealing with emotions, not in dealing with apathy, enhancing apathy. You know, are you suggesting that you want the AI to do a configuration of looking at the eyes of the parties and see their emotions and decide what percentage of stress they are under at the moment in this topic that we're talking about in this hour? Or in the next hour, are you asking the AI to figure out whether or not there's a 50% chance that the one party is going to agree to this, or as opposed to 60% chance whether we should go down the path? I don't think we are anywhere near any of those kind of things. All right. Next question: can you summarize the Singapore Convention and what the judgment is through it? Yes. At the end of this presentation, by tomorrow morning, my paper on this talk is going to be up. I've summarized some of the critical points of the convention that is relevant to mediation, right? I mean, relevant to ODR. I've highlighted that, so you can take a look at that. Remember, it's not a judgment; it's a settlement agreement that parties get through, and you really need to appreciate the fundamentals of mediation. Back to that again. Also, how would it impact countries which sign it and countries which did not sign it? Simple. It's just like the New York Convention. The countries that sign it and put it into force, if you have a mediated settlement that that one party defaults on, and you can go get it enforced in the country. If the country that has a signatory to the Singapore Convention has got assets of the defaulting party, then you can go get the settlement agreement enforced in that country, very similar to the New York Convention. So that's pretty straightforward, I think. Also, how would it impact? Well, that's the point about impacting on countries that don't. Okay. The New York Convention has got 160 countries, with the latest country just ratifying it about a month ago. That's the 160th or 61st country. So, you know, it can take time. The New York Convention was 1956 or 58, and it's taken this long to get to 160. But the Singapore Convention on Mediation has taken 46. We're now up to 50, if I'm not mistaken. And we're going to move a lot faster, and we're going to get there a lot sooner. All right. Next one. Thank you very much for the presentation. Specifically regarding the requirements set forth in Article 4.2 of the Singapore Convention, use of electronic communication, do you consider it appropriate that the future ODR platform provide reliable electronic evidence on the identity and the signature of the parties from the mediators, and above all, that the mediation process has been carried out what is it saying? Mediation proceeding has been carried out and concluded. Electronic certificate of mediation. Now, I'm just taking a look at Article 4.2. I can't off the top of my head remember what exactly the details are, but you know, even if you go online and you settle a mediation, there's nothing wrong with you sending it off to the party physically and having the party sign off and then sending it back, so that electronic evidence and electronic signature may not be a problem. Okay, so just this week I've been appointed in an adjudication as a dispute board adjudicator for a single adjudicator for a dispute board in one country. The agreement was just sent by courier from the claimant's country. It was sent to not the claimant, but the party A, sent it to a second country, party B. They got it signed, and then they've sent it to me. That process has only taken 2 or 3 weeks. So we have actually physically signed off on the document. So it's not a problem. You know, while you have an ODR platform that you resolve a dispute, parties can sign off electronically for now, but if you feel that you need the physical copy of the original signatures, it's just a matter of a week to get it sent off. You know, first party can sign off and courier it off, and it'll move, and within a week you'd have it all signed and sealed and then sent back to the parties. For example, in my adjudicator appointment, it's 3 copies, so I'm retaining 1 copy, physical copy, so it doesn't matter. Now I'm just quickly taking a look at Article 4.2. Let me just see what it says. Right, but I don't mind adding a point of that requirement that a settlement agreement shall be signed off. A method used to identify parties and mediators to indicate the parties mediators' intention in respect of info contained in the communication. Let me take a little bit more look at that, but I'll cover that in my. Okay, well, so, no, so it's 4.2, Article 4.2. Where's 4.2? Okay, 4.2 says that the requirement. So I'll read off. Article 4.2 says the requirement that a settlement agreement shall be signed by the parties, or where applicable, the mediator, is met in relation to an electronic communication if a method is used to identify the parties or the mediator, or to indicate the parties and the mediator's intention in respect of information contained in electronic communication. I really have to take a look at this. I don't know whether this is effectively talking about, oh yes, it is talking about a settlement agreement, but I'll take a look at that, and I don't really see a difficulty of ensuring that those requirements are satisfied. But I'll add that to my paper when I'm doing the presentation, if that's all right. My apologies on the full details of that not being available in answering your question. All right, where are we now?
So Anil, I think we've managed to get through the Q&A, and I've had to tell a few people we'll need to get back to some other time. Okay. So thank you everybody for your fantastic questions. Thank you so much to Anil for joining us and for your great presentation. And so everybody, we will put a post up on the IMI and SIMI websites later on with the video and with the links discussed in this presentation. So thank you again to all.
Thank you. Thank you very much.